Well, I wouldn't talk of a complete success, but I do think that it set certain directions. And therefore, that direction is the principal achievement, I think, if I can call it that, is the growth of a realization within government, particularly in government, that information held by the government must be given when asked for. This is quite a radical change from what there was before, when we were not only conditioned but actually trained to believe that information that is held by government is held in trust for the government and should never be given unless you are compelled to do so. And even when you're compelled to do so, as in the case of maybe a parliament question, you must give it in a way that you give away as little as possible. I think these conflict areas have been diminishing. As you know, there was this feeling that file noting should not be given. Something that the DOPT, which is the Administrative Ministry for the Right to Information Act, had taken a stand. It took some time, but the DOPT itself has come out with a circular, an OM, in the DOPT that no, it must be given unless it is exempt from disclosure under the RTI Act. So that was one area which was a sort of ongoing area of conflict. Another area was the area of up to what extent are the High Courts and the Supreme Court or the judiciary subject to the RTI Act. I think there also we have had a reconciliation in the sense that it is recognized, and that also by the Commission, that High Court rules with regard to judicial functions are the rules which are valid under the RTI Act. It does not mean that the information cannot be sought under the RTI Act, but it only means that the procedure for obtaining that information is to be taken under the High Court rules and not under the High and Supreme Court rules, which deal with disclosure of information and disclosure of official judicial records. Well, the drawbacks have really come from what one may call teething problems. The Commission itself was not very sure as to the extent of its authority. The government was not sure of the extent of the authority that it had granted, that the Parliament had granted to the Commission. So there were those areas which accounted for the areas of conflict. A stand was taken by the former Chief Justice of India that the Office of Chief Justice of India, being a constitutional authority, does not come under the Act at all. Now, of course, that the Supreme Court itself has retreated from that position. But these were difficulties in the initial, so far as understanding of the law is concerned. The second thing was that, of course, there were the administrative problems, the financial problems. We didn't have money, we didn't have proper premises. We were in a hostel building, and the hostel room was our office room, where we had to have hearings and all. So that is in the old JNU campus. So we have acquired our premises. We still don't have a permanent premises of our own. I believe the government has recently taken a decision to give us property on which we can build our offices. These difficulties persist, but staffing continues to be a problem. I think basically there has not been the kind of understanding in government. As I said, initially also we had this, that people within government didn't understand the law, people outside, even we did not. But inside government, a certain degree of misunderstanding still subsists. And it's not only in government, it is among the activists also. And that is why I have been disputing this expression of the RTI being characterized as a weapon against the government. The levels of awareness of the RTI Act owe much to NGOs, primarily to NGOs, but NGOs have been largely focused in the larger cities, and therefore that accounts for the fact that in larger cities the awareness of the Act is also high, and the use of the Act is also high. The system of providing information in the rural areas has not been properly systematized. In certain areas it is very strong, like in Rajasthan, but that owes a lot to people like Aruna Roy and the MKSS, who's actually the whole program is initiated there from the rural areas. Therefore, people at the village level are very aware, and therefore they're demanding, and therefore the systems are there. Where at the top level, the apex level, the system is somewhat weak in Rajasthan, comparatively. But given this, the fact that in Rajasthan this is the case, the government already has a program of, the CSC, the Common Service Centres, which is going to be expanded across every district of the country. The idea being to provide computerized facilities right down to the district level, at least up to the district level, if not beyond. Now that will become, I foresee that the principal use of that, other than perhaps Shadi.com, will be use of the RTI.